I welcome you here to this academic session in which Professor Jure Vidmar, appointed at the Faculty of Law as Professor of Public International Law, will give his inaugural lecture. The title of this lecture is Wrongfulness, Responsibilities, and Defenses in International Law. Professor Vidmar, I invite you here to the floor and to give your inaugural lecture.
Mevrouw de decaan, geachte collega's, vrienden en familie. Het is voor mij een grote eer met deze oratie de positie van hoogleraar in de internationale recht aan de Universiteit Maastricht te aanvaarden. In het bijzonder vervult het mij met nederigheid dit te doen in de aanwezigheid van professor Theo van Boven en professor Menno Kamminga, mijn voorgangers aan deze leerstoel. Nu even in het Engels. In my lecture today, I intend to identify some conceptual problems and structural cracks in international law. I will talk about the relationship between the concepts of wrongfulness, responsibility, and defenses, and use this relationship as a tool to first address certain theoretical misconceptions of international law, and secondly, to demonstrate how such theoretical misconceptions lead to problems in the practical application of international legal regulation. But in order to do that, I first need to explain how I understand the nature and method of international law. Even in the age when impact and societal relevance are the driving forces of research, I tend to believe in the need to invest in theory, even where its impact is not immediately obvious, as we do not know what may happen in the future. That theory that we may be developing might be important. If I may borrow from another discipline, physics, we know of a certain Albert Einstein and the theory of relativity. But then, quite recently, a professor of physics, Clifford Will, stated that next time you are taking a flight, think about Einstein and the GPS tracker in the cockpit, helping the pilots guide you to a safe landing. Namely, Professor Will continues, without the proper application of the relativity, GPS would fail in its navigation functions within about 2 minutes. So, if a certain anonymous theoretician working in Zurich and Berlin some 100 years ago were asked at the time what the impact of his work were, I don't think he could have said 100 years from now 3.6 billion air passengers will be flown per year in the aeroplanes using satellite navigation, which will only be able to operate properly if this theory will be applied. Not even Einstein himself had a clue of the full extent of the impact of his theoretical work, that his theoretical work would have in the future. And it goes without saying that we cannot dismiss it simply because we cannot predict world events and identify all the possible benefits, speaking from the standpoint of this very moment. In international law, theoretical work counts toward the subsidiary legal sources. Of course, one could also theorize about the question of what theoretical work is in legal science these days. Let me illustrate. Most of you are familiar with the relatively recent incident in South Africa when the president of Sudan, Omar al-Bashir, participated in the summit of the African Union. The International Criminal Court had previously issued an arrest warrant for him, but he has immunity as a head of state under customary international law. Nevertheless, the Rome Statute of the ICC overrides such immunities. Problem, Sudan is not a party to it. Nevertheless, the referral of the Sudan situation to the ICC came by virtue of UN Security Council Chapter 7 resolution, which makes it binding on everyone. I'm not going into the substantive details of this incident, especially not in the presence of Erika de Wet, but I will only say something at the conceptual level. The decision whether or not to arrest al-Bashir, the question ultimately of yes or no, requires a nuanced prior theoretical work on the relationship between treaty law and customary international law, between bilateral obligations and multilateral treaty obligations, of the effect of Chapter 7 resolutions, Article 103 of the Charter, and a number of other doctrinal matters. But if you put it like that, in purely theoretical terms, at a time when you couldn't possibly know that al-Bashir was going to make a trip to South Africa in the future, some would say, well, the relationship between treaty and custom, Chapter 7, Article 103, this is so very doctrinal. How will this ever save the world? And others might ask, what is the Foucauldian perspective on that? And then a real problem, a real situation arises, and a legally sound decision needs to be made, a defensible legal advice needs to be given, and then a sound legal advice is not. Well, if international law is apology, arrest him. If it is utopia, then don't. To be sure, it is important to theorize international law also from more abstract aspects, but it is wrong to start with international law at an abstract stage. A good legal argument does not shy away from the storms of social reality. It goes there, but also safely brings it back to the formal sources of Article 38.1 of the statute, of the ICJ statute. Good scholarship may even formally be a subsidiary source of law. It can fix a small but pressing legal problem and add yet another small piece into the puzzle of the international legal system. And with this piece, further diminish the zone of dangerous ambiguity in international legal regulation, even if it does not immediately save the world. As legal scholars, I believe we are tool makers. We should be developing the tools to be used by the decision makers and individuals when they need to fix legal problems or address the legal challenges of social reality. Of course, the danger is that these tools are misused by others, as any tool can be misused. A hammer can be used to fix your car or to smash it. We can't control who and how we'll be using the tools we have manufactured. But then it is also our duty to develop in scholarship the manuals on the usage of the tools and raise our voice when such tools are not used properly. We also need to know that what international law can do at all and what its limits are. What kind of tool it is. A sledgehammer may be quite a useful tool for many purposes, but it would certainly disappoint you if you try to fix your precious Swiss watch using it. Sometimes we hear voices how ineffective international law is. Indeed, so ineffective that it is not even law. But then, every time we see a reckless driver in the streets of Maastricht, do we start asking ourselves whether Dutch law is law, properly so called? Do we say that Dutch law, if it is law at all, would cause a collision and fatalities? No. But then we often try to hold international law to a higher standard than we do in domestic law. And in a domestic law, we also have situations of, say, reckless drivers, organized crime, and the ability of the more powerful to get away with severe breaches of legal rules. It also needs to be kept in mind that international law has never killed anyone or committed genocide. This was done by people, often, but not always, by breaching international law. And when we say breaching international law, what exactly do we mean? We often read in the media or hear politicians and the general public saying how this or that was against international law, but we always need to ask ourselves precisely which legal norm was breached by a certain conduct, and whether there was a legal norm present in the first place, in the sense of Article 38.1 of the ICJ statute. Was the legal norm we are talking about even binding on the actor who allegedly breached it? Can the actor involved in a certain conduct we are questioning even breach international law? Answering these questions will tell us what kind of tool international law is, so that we do not expect of it too little, or sometimes even worse, too much. And this is what I intend to address in the rest of my lecture. Why conduct sometimes appears to be wrongful, but is actually not. Why are certain actors capable of causing harm, but escape international responsibility? And then I will question the theoretical distinction between primary and secondary rules of international law and say that it doesn't really work in theory or practice. International law is a legal system derived from states. This is not to say that we do not have actors other than states in this system, but states are the actors which have the full international legal capacity. This also follows from the formal sources of law. It is states who conclude treaties in the sense of the Vienna Convention. It is states who generate state practice and opinio juris, again derived from states, and this forms customary international law. International treaties can be of various kinds. They can be bilateral, multilateral, or indeed so multilateral that they are virtually universal. They can regulate something quite technical and specific, such as construction of waterways in the border area between two states, or establish something as complex as the United Nations or the European Union. Treaties between states can thus create international organizations and other legal creatures with their own organs, which can also make autonomous decisions, at least to some extent, some more than others, again depending on what states have agreed in the underlying treaty. In some instances, we may ask ourselves if states do not sometimes create a Frankenstein over whom they lose control. Some would say that perhaps EU may be such a creature, especially where its court of justice is acting in unpredictable ways. But that is another issue which I'm not going to discuss today in the presence of some very eminent EU lawyers. When the UN Security Council adopts a legally binding resolution, its binding nature is anchored in Chapter 7 of the UN Charter, which is an international treaty. So even the so-called lawmaking powers of the UN and international organizations can be traced back to states, more specifically to the very specific treaty, which has been, in the case of the UN Charter, ratified by nearly all states in the world. And it is a selection of states who are voting in the Security Council anyway. It is not really an autonomous organ. The General Assembly resolutions aren't legally binding, but they may be relevant for the identification of customary international law. And it is against states who are voting in the General Assembly. In a sense, this body may be, among other things, seen as a provider of secretarial services for the identification of international custom. It is always tricky to identify what states believe for the purposes of opinio juris, but the General Assembly is one place where states really go on the record. Now, in terms of legal capacity, international lawmaking appears to be a prerogative of states, although that sometimes happens indirectly and through international organizations where states act collectively. How about law breaching? Is it also only a prerogative of states? Here we come to the question of capacity to commit an internationally wrongful act. In other words, can only an act of state be an internationally wrongful act? And what is actually an act of state? Before I proceed, I need to add a bit more on the international legal personality and capacity. We have several actors in the international system who are, however, not identical in their legal capacity. Already in the reparations advisory opinion, shortly after World War II, the ICJ acknowledged that rights and duties under international law were not only inherent in states, but also in international organizations. The court importantly added that this does not mean that the level of these rights and duties is the same as that of states, but that even international organizations have international legal capacity for the purposes of their functioning. The rise of international human rights law also gives international legal capacity to individuals, as does international refugee law, while international criminal law sanctions individuals as perpetrators of war crimes, crimes against humanity. But we should not forget that even in these instances, we still have in the background treaties concluded by states, as well as customary international law, which is shaped and formed by states. Even in a municipal legal order, we have human beings and we have corporations, with personality, but for different purposes in a legal order. But then we certainly have also other actors involved. For example, wild animals. A range of legal rules protect them against animal cruelty and regulate hunting. On the other hand, legal rules also regulate liability when animals cause harm. This, of course, does not mean that a shark would be charged with the crime of murder and go to jail for killing a surfer, or that a bear would be charged with animal cruelty and will also need to pay damages if he attacks your cattle. Although animals enjoy a level of protection in our human legal systems, their legal capacity is not such that they would be liable for breaching our laws. In some circumstances, it may be, however, that humans, or sometimes even corporations, who do have such capacity would be liable for the conduct of these animals. Factual harm caused by an animal may well be crime or tort in law. Not that of a shark or bear, of course. We will need to attribute that conduct to someone with such level of legal personality to even have the capacity to commit crime or be liable for damages under tort law. In essence, in every legal systems, we have actors who are capable of causing factual harm and may even be capable of being harmed themselves, but do not have the legal capacity to be legally responsible for their conduct. In the end, their conduct will be wrongful only if an actor with an adequate level of legal capacity can be made liable for it. And here I will now turn back to international law, where we have this division between the primary and secondary rules. The primary rules are set to determine which conduct is or is not wrongful, while the secondary ones regulate responsibility for wrongfulness. Yet, I will submit here that the secondary rules on responsibility overlap with the concept of legal capacity. It is thus the law of responsibility which actually determines whether or not a certain conduct whether or not in a certain conduct we can even identify an actor with the legal capacity to breach international law. It is not a coincidence that of all actors, international law regulates only responsibility of states and international organizations. While there is very limited category of international criminal responsibility of individuals, I will explain later why that actually works differently. It is thus only states and to a limited extent international organizations who are even conceptually capable of violating international law. I will now proceed with the law of state responsibility, yet to the extent to which certain rules of international law are applicable also to international organizations, the reasoning could be extended also to them. As I said, the law of state responsibility is said to be secondary in nature. As the ICJ, the International Court of Justice, put it in the Gabčíkovo-Nagymaros case, I quote, "A determination of whether a convention is or is not in force and whether it has or has not been properly suspended or denounced is to be made pursuant to the law of treaties. On the other hand, an evaluation of the extent to which the suspension or denunciation of a convention seen as incompatible with the law of treaties involves the responsibility of the state which proceeded to it is to be made under the law of state responsibility," unquote. Sounds quite reasonable. This is a two-step approach. Wrongfulness is identified under the primary norm, in this case originated in treaty law, and once this has been done, the law of state responsibility is used to determine the consequences of wrongfulness. But the problem is that this approach only works where the conduct we are analyzing can, by definition, only be an act of state, which is what the factual circumstances were in Gabčíkovo-Nagymaros. In order to suspend or denounce a treaty, the state needs to act through its organs. I cannot now suspend a treaty, wrongfully or rightfully, to which the Netherlands is a party. Only state organs can actually do something like that. Or if I refer to the example I used at the beginning, only the state organs of South Africa could arrest or fail to arrest al-Bashir when he was visiting that country with an ICC arrest warrant around his neck. The problem is that not all international conduct is so straightforward, and even here things can complicate. States do not only act through their organs in a sense of Article 4 of the Articles on Responsibility of States for International Wrongful Acts, or ARCIWA. Article 4 says the conduct of any state organ shall be considered an act of that state under international law, whether the organ exercises legislative, executive, judicial, or any other functions. But in a number of other situations, a certain conduct may or may not be an act of state, depending on the circumstances. While I cannot suspend a treaty to which the Netherlands is a party, I may be able to put the Netherlands in violation of that treaty, provided that that act becomes attributable to the Netherlands. Now, contrast Article 4 with Article 8, and I could quote also some other articles here, but let's contrast it with Article 8. The conduct of a person or group of persons shall be considered an act of a state under international law if the person or group of persons is in fact acting on the instructions of or under the direction or control of that state in carrying out the conduct. This is much more complicated. Unlike in Gabčíkovo-Nagymaros types of situations, in Article 8 situation, we do not start with the assumption that the conduct at stake even was an act of state. We have conduct which could be internationally wrongful if it were attributable to a state. Then, in the Nicaragua case, the ICJ had to consider whether the conduct of the Nicaraguan Contras was attributable to the United States. The ICJ established a very, very high threshold for attribution. Essentially, where a state does not have a full overall territorial control, it does not incur responsibility if it is merely financing, training, and otherwise supporting rebels in a foreign state. It needs to be proven that the foreign state had effective control of the operation in which the alleged violations happened. And this may be quite difficult to prove. It's even worse. In the Nicaragua case, the ICJ talked about responsibility. But I will now demonstrate that this creates a gap, not only in responsibility. It can also mean that the entire conduct was not internationally wrongful. You will all be familiar with downing of MH17, which very tragically affected also this country. It happened in the territory of Ukraine, over which that state does not exercise its effective control, so in that part of the territory. It is believed that the plane was shot down by the insurgents, who were fighting against the government of Ukraine, but they are not a state. Common knowledge tells us that the insurgents are backed by Russia. But do we have enough evidence to conclude that the rather demanding Nicaragua threshold, which I just quoted, for attribution to a foreign state had been met? Maybe yes, maybe not. It is difficult to speculate about that, and I quite frankly don't know, because I don't have access to any government documents and I can't see the evidence. But look at the question conceptually. This is not like suspension of a treaty from Gabčíkovo-Nagymaros. In that case, the treaty could have been wrongfully suspended only if this was an act of state. But in the case of MH17, a civilian aircraft was shot down and people deprived of their lives, regardless of whether or not this was an act of state. The tragic event is a matter of fact, and now we need to attach the law to it. It will be an act of state only if the conduct is attributable to a state. As it is not known whether or not this was an act of state in the end, we need to start with attribution, which is a part of the so-called secondary rules on state responsibility. So the two-step approach here does not work. The strict separation of the primary and secondary rules do not work. We necessarily get a conflation. What is more, if the conduct cannot be attributed to either state involved in the situation, so Ukraine or Russia, does this actually mean that they escape responsibility, or indeed that this was not an internationally wrongful act in the first place? Well, pursuant to Article 2 of our SIVA, it is the latter. Now, if you read the article carefully, it says, there is an internationally wrongful act of a state when conduct consisting of an act or omission is attributable to the state under international law and constitutes a breach of an international obligation of the state. First of all, Article 2 of our SIVA refers us to the rules of attribution, which are, however, also a part of the secondary rules of state responsibility. And secondly, what follows from this formulation is that until conduct cannot be attributed to a state, wrongfulness remains purely notional, and as such, it is not an internationally wrongful act. This is indeed a structural crack of international law, limited international legal capacity of non-states, and the high threshold of attribution to states. Skip this. Now, what I have argued for now is Yeah, so we cannot strictly separate the primary and the secondary rules. And I will now use another example, the notorious Tadić case, and that we necessarily get a conflation. This was a much criticized judgment of the International Criminal Tribunal for the former Yugoslavia. The ICTY used the attribution rules from the law of state responsibility to determine whether the armed conflict in Bosnia, which was prima facie of a non-international nature, had been internationalized by the involvement of a foreign state. As we know, this distinction is very crucial, as quite different rules may apply in different types of armed conflict. To put it simply, if the identification of the primary legal rules of armed conflict depended on whether or not certain acts of Bosnian Serbs could be attributed to what was then the Federal Republic of Yugoslavia, then it was an international armed conflict. Otherwise, it was a non-international. As this was an ICTY case, it was about international criminal responsibility of an individual. But it was first necessary to establish what the applicable rules were in that situation. And for that, the ICTY, in my view, quite logically resorted to the attribution rules. Criticism to this approach is based on a dogmatic distinction between the primary and secondary rules. The critics say that the secondary attribution rules should not have been applied before wrongfulness was determined under the primary rules, and also that state responsibility should have had no place in a case concerned with individual criminal responsibility. But I disagree with such assertions. As Judge Cassese later writing as Professor Cassese said, I quote, "The ICTY admittedly had to establish in Tadić whether the armed conflict in Bosnia was internal or international. However, as no rules of international humanitarian law were of assistance for such determination, the tribunal explicitly decided to rely upon international rules of state responsibility." Indeed, how else could a tribunal determine whether or not a foreign state was involved enough that an internal conflict had become an international one in which quite different rules may apply? One may believe that the attribution rules are secondary in nature and interprets but if one interprets the secondary nature as an order of sequence, how exactly do you then identify the actors in a certain conduct and thus determine applicable law? I think so, and in any case, the applicable law will crucially depend on the actors, even if we do not have IHL situations and armed conflicts involved. But for example, a treaty may be binding between states A and B, but not between B and C. And then attribution becomes crucially important for the identification of the law. So whether we even have, whether the act is or omission is even attributed to an actor who is actually bound by the treaty. Now, returning to Tadić, at this point, I will omit the question of whether or not the tribunal was right when it attributed the conduct to the Federal Republic of Yugoslavia, and in so doing departed from the Nicaragua test of attribution. Actually, at this point of my argument, this is not of crucial importance. What we need to know is that whether we like it or not, the ICJ sticks to the Nicaragua test, and we thus have to live with it in general international law, regardless what we think of the Nicaragua test or of the ICTY and of the Tadić attribution threshold. But now I was not talking about the threshold for attribution. I'm talking about the importance of attribution conceptually, and that it actually determines the applicable primary rules. The second alleged problem in Tadic is that state responsibility was conflated with individual criminal responsibility. But I do not quite agree either. The problem is that even with international criminal responsibility, we still have states in the background, as individual crimes are derived from violations of international humanitarian law. And in IHL, again, the identity of the actors determines the applicable law. If we originate from the general principle of criminal law, nullum crimen nulla poena sine lege, we indeed first need to know the applicable law. We need to identify lege before we can have crimen and poena. And how could the ICTY do that in Tadic without resorting to the rules of attribution first? Only at this stage did it become clear what international crimes Duško Tadic could have committed. So in international law, we always end up coming back to states. Even individual criminal responsibility is not materialized out of thin air. It is grounded in the formal sources of law. It takes you back to states, and the attribution rules under the law of state responsibility may be very important for determining the actors, and this is what then also determines what the applicable law is. The conflation of the so-called primary rules and secondary rules is obvious perhaps even more directly in the concept of defenses or circumstances that preclude wrongfulness, as they are termed in the Arsiva. The first problem is already the title, circumstances that preclude wrongfulness. How could the secondary rules of state responsibility preclude wrongfulness if they didn't interfere with determination of wrongfulness? This would seem to be a task for the primary rules. The secondary ones could only preclude responsibility for wrongfulness, but not wrongfulness itself. The Arsiva then lists those circumstances and indeed conflate them. Some in which responsibility may be precluded, for example, necessity or force majeure, and others which actually preclude wrongfulness itself, self-defense, pursuant to Article 51 of the UN Charter. Article 51 is indeed a way out of wrongfulness mandated by Article 2.4 of the Charter. It is a legally warranted departure from the original prohibition of the use of force. On the other hand, if a military aircraft violates the airspace of another state due to severe weather or mechanical failure, this is not a legally warranted departure from the original norm. So wrongfulness is still there, but necessity or force majeure may indeed preclude responsibility for it. This is quite different, and this is a typical distinction between justifications and excuses, as it is known in domestic, criminal, and tort law. A justification is a legally warranted departure from the original prohibition, such as taking life in self-defense. An act may be wrongful prima facie, but a justification takes you out of illegality altogether. It is indeed a circumstance that precludes wrongfulness. Article 51 is, in my view, a very good example of how a justification may conceptually work in international law. It is included in the Charter, a treaty, and rightly so, but what is it then also doing in Article 21 of the Arsiva? When force is used pursuant to Article 51, it is not wrongful in the first place, and which is actually in line with the title of the chapter, so circumstances that preclude wrongfulness, but the problem is that that title is also wrong, so we have double confusion here. On the other hand, when we have an excuse, as opposed to a justification, we admit that our act was wrongful, but we claim that we had a good reason for breaching the law. In a domestic setting, that would be emergency drivers. So you admit that you are driving too fast, and you do not dispute that, but you say, but in these circumstances, it was better because I was rushing somebody to hospital and was saving this person's life. So this is the logic of excuses which domestic legal systems adopt. And I think in international law, it operates behind the concepts of force majeure and necessity in the law of state responsibility. So wrongfulness remains there, and we do not deny it. We just do not accept responsibility for it. So in this theoretical exercise, I try to show that the concepts of wrongfulness, responsibility, and defenses in international law actually aren't separated as strictly as we sometimes believe they are, or indeed are supposed to believe, on the basis that primary and secondary rules are separate and we should not be conflating them. An act may be conceptually wrongful if it cannot be attributed to an actor which can incur international responsibility. And then we have some defenses which can preclude wrongfulness and others which can preclude responsibility. And both types are somehow mysteriously a part of the secondary rules on responsibility. Now, the distinction between primary and secondary rules, I think, can be at times arbitrary and confusing. Many rules from the law of state responsibility, as I have just argued, are also found in the so-called primary rules. And it is not entirely clear what then they're doing in the body of the secondary ones, which regulate wrongfulness, which do not regulate wrongfulness, but only responsibility. Or perhaps the conflation of such concepts isn't really accidental, as you indeed cannot separate the concepts of responsibility and legal capacity for wrongdoing. Let me now illustrate and sum up. In an Article 4 of our SIVA situation, we have conduct, which is by definition an act of state. If the conduct is in breach of a legal obligation of this state, it is internationally wrongful, and the state will incur responsibility. But this only works because the conduct and the act of state are the same thing. But then we have Article 8 situation, where we have conduct, and then we have attribution. And if a conduct is an act of state, then there is breach of an obligation, or it is a breach of an obligation is even conceptually possible. If it is not an act of state, breach of an obligation is conceptually not possible. So what that means is that we sort of get a circle. We get conduct, we have conduct, then we need to establish attribution and whether that conduct was an act of state, and then we have, only then we can establish wrongfulness, and then we come to the level of responsibility, but the problem is that the law of responsibility again decides whether or not a certain conduct was an act of state, so that attribution is also under the law of responsibility. And pursuant to Article 2 of our SIVA, if a certain conduct was not an act of state, this is actually not a way out of responsibility, but a way out of wrongfulness altogether. So what we could then do, we could try attribution to an international organization, and if even that fails, as they have even fewer legal obligations than states anyway, we are left with no actor who could incur responsibility and whose conduct is even conceptually able to be wrongful. This theoretical exercise is reflected in a number of difficult practical questions. I have mentioned the Tadic case, where the secondary rules determine the primary rules, which primary rules were applicable in the first place. We have MH17, and where wrongfulness depends on attribution. And then we have effective territorial entities falling short of statehood. So is an attack on Taiwan a violation of Article 2.4? And what if a third state, not China, attacks Taiwan? Is that an attack on Taiwan or China indeed? And to whom are attributable the incursions from the territory of Somaliland into Ethiopia? And not to mention that even in Europe, we still have not a completely settled question of Kosovo and what its legal capacity is. And then in international legal scholarship, many suggestions have been made to address the symptoms of this underlying disease of international law. Some of them more plausible than others. There is much discussion on the right to self-defense against non-state actors and on the so-called unable and unwilling doctrine. But do we really want to go down that road and further mess up the substantive rules on the law of self-defense? And are the problems of Taiwan, Somaliland, and even Kosovo actually problems of the law of statehood, or rather problems of the unclear concept of international legal capacity? The questionable new doctrines are trying to deal with some symptoms, I think, of the bigger conceptual problem. And this is international legal responsibility, and thus the capacity for wrongdoing is prerogative of states, while the attribution threshold of the conduct of non-state entities to states is very high. And while already in 1949, the ICJ introduced the sliding scale principle to the concept of international legal personality, we still do not know how exactly that sliding scale works. And I think this is a big problem of public international law. Now, a part of my path as a student, the young professional went through the city of Salzburg. For this reason, I may be excused, though definitely not justified, if I quote, not him, but Salzburg is also known for some other sounds of music. And there is a scene in which Mother Superior says to Fräulein Maria, when God closes the door, he somewhere opens the window. And my career and life in general, I can say, have been full of such doors and windows. And unlike Fräulein Maria, I didn't even need any divine interventions, as I have met plenty of people who were constantly opening those windows for me, some of them sitting here today. I'm thankful to the law faculty of Maastricht University to have entrusted me with this responsibility to step in the exceptionally big shoes of my great predecessors, very distinguished professors Theo van Boven and Menno Kamminga. I'm thankful to the committee who selected me. Clearly, I'm very thankful to Dean Professor Hildegard Schneider. I'm thankful to the head of the department, Professor Monica Klaas. I'm thankful to Professor Bruno de Witte, thankful to Professor Peter van den Bosse, who couldn't be here today either. I very much enjoy working with my colleagues, with many of you here in Maastricht, especially those of you with whom I work very closely. I have had wonderful discussions with Professor Kees Flinterman, and it is amazing that you're here, my colleague. And I have had wonderful discussions with some of our younger colleagues, like Jennifer Selin, Laura Visser, Wim Miller, Remy Joritsma, and Fabian Raimondo, who introduced me to this faculty, who mentored me essentially in my first 2-3 months here when I didn't even know into which office to go. I am very thankful also to my students who are constantly convincing me how rewarding the work of a teacher is. Their achievements keep me going even in those gloomy moments when I'm marking already the 400th exam paper. But then it is always very exciting to hear what my former students are up to. And the old wisdom is that you're a good teacher when your student becomes better than you are. And looking at some of my former students, I can say that this might have happened to me a bit sooner than I expected. And looking at some of you in the audience, embarking on exciting PhD projects and taking up exciting jobs in practice or moving to exciting places, I feel that I do need to pull up my socks, and you also make me very proud. And while it is always risky when you are naming individuals, assumptions can indeed be very, very wrongful of others not members of the Maastricht faculty. I would very much like to thank Professor Erika de Wet for opening several windows on my path as a legal scholar when it mattered most. Finally, it is important to remember that we also have our lives outside of academia or other professional activities. And there are people who have supported us through many, many struggles and will always be there, even where we are overworked and unduly neglect them. And sitting in the first row, I am very thankful to my parents, Nada and Stane, for their constant support and understanding, and for a nice life they gave me when I was growing up, where things were not always that easy, but I couldn't feel that. I'm thankful to Rebecca, wonderful scholar, musician, and my muse, who is showing me every day that responsibility is not only a legal category, and that it does exist even without wrongdoing. And I still owe you that excuse for bringing up the sound of music. A very famous philosopher and my fellow Slovenian, Slavoj Žižek, no less, once said that watching cheesy films is one of those guilty pleasures we are reluctant to admit, yet we all know everything about them. We have all seen them. The Sound of Music, Žižek says, is a much trickier film than one might expect. And here, my dear colleagues, I broke the promise of legal formalism that I announced at the beginning. I ended with Žižek, the prophet of critical theory. But this is not an announcement that I want to convert to critical scholarship. And if I wanted to convert, I would have probably entitled this lecture State Irresponsibility, Learning from Žižek and Einstein. But I didn't. I have it a doctrinal title on purpose. Ik heb gezegd.
So, dear Professor Vidmar, dear Jure, thank you very much for this very interesting, doctrinal, legally very inspiring lecture, and of course also very nice to go back to the Sound of Music and the opening of the window, so I'm very happy. I remember when I studied in Paris, actually, and it was raining and sometimes the cars were, and actually the study was not always so funny. I once went to listening and watching Sound of Music, and it helped me really to enjoy Paris again. So, so when I saw this, I thought, okay, yes, it is what I admitted I once watched, and my children watched it nearly every night. So thank you very much for reminding also on this very wrong pleasures perhaps we sometimes have. Now, talking about wrong pleasures, of course, to inaugural lecture always is also drinks. So if you want to congratulate the appointed or accepted professor, I would like to invite you for drinks in the rafter, or I guess now still outside, and you can follow us as Corona, and you will find the young professor there. So thank you very much. I close this academic session. I also would like to congratulate the family, the parents and Rebecca, and I hereby close this session. Welcome to our faculty. So.